direction, and then we take input from all members, and we come together and hopefully get something that we can agree with, at least the majority of us can agree with. So this process will continue from here to respond to other members up until the point where the rules are adopted. It's also just rules that we're talking about today, but one of the things that we're going to begin the process about is what laws need to change as well. Clearly, we don't have the ability to come in unless the governor calls us into special session and change laws, and that probably requires a little bit more thought. I do expect we'll have some legislative changes that may be necessary in January. But we can accomplish most of what we want to accomplish through rule changes, and that's what we're going to do. So let me just go through this. As you know, this is an amendment of Section 24 of our Senate rules, which has to do with ethics. And if you look in Section 24.02, that's the definitions section. There's a couple changes, and one is we added employee, consultant to the meaning of financial interest. So through our rules now, it basically refers to financial interest, but in the past, it's just referred to if you own part of the business or part of the institution that may have business before the state. Well, we've made that much broader to include anybody who is an employee or a consultant, and then we also define what a consultant is. Basically, anyone who gives expert or professional advice. We didn't change 24.03. It's basically the same statement that's in our current rules, which says legislators comply with the laws. 24.04 provides for the possibility that any member who has a question about is this an ethical violation, which certainly may be a case as we change all these rules, has the ability to ask the Ethics Committee, which I'll be talking more about in a minute, for an advisory opinion about whether or not their particular activity or employment situation or anything else would be in conflict. So this Ethics Committee will serve the purpose of providing advisory opinions. 24.05 is basically replaced with new language in 24.06, which we'll talk about in a minute. And now it's 24.05 is just the same language that we have with regard to any state contracts that legislators may have with the state government. That requirement hasn't changed. It has to go through public bidding process. 24.06 is really the meat of this. It changes the title from conflicts to make it conflicts and prohibited conduct. So it establishes certain activities that are prohibited. So again, rather than just declaring these as a conflict, that there may be some disclosure requirement that says, no, this is a prohibited conduct, and we want to go through those. So again, this is on page 3 of your phone, but it's section 24.06. But let me just explain what the prohibited conduct or conflicts are. Solicit or agree to accept a benefit for public duties. So someone pays you to do something in your role as a state senator. Accept employment or compensation that could be reasonably expected to impair his or her independence of judgment. Knowingly accept, use, allocate, or grant or award public funds other than that approved by law. Acquire a financial interest based on a policy that you know is about to change. This is similar to insider trading rules. If you know that something's going to change in the industry that will benefit a particular industry, you can't take that knowledge and then go invest in that industry. Pay below or charge above fair market value for goods or services with any lobbyist or entity that does business with the state. So no sweetheart deals, either renting an apartment or leasing an apartment to somebody else or any other goods or service. It has to be a fair market value when you're talking about somebody who does business with the state or as a lobbyist. Take any action adverse to a competitor or business they or family are involved in. So you can't use your position as a legislator to give yourself a business advantage in any way. This next part is somewhat complicated, but basically you cannot participate in a discussion that may benefit a business that they're involved in or financial interest that they're involved in, or will specifically relate to a business that they receive compensation as an attorney or a consultant. So